And I think with that, we can go ahead and jump into it. Today's webinar will feature WELC Senior Attorney Andrew Hawley and Deal Fellow Michelle Hoagie, who will be diving into our latest legal victory on factory farm pollution and our role in the ongoing fight to the Columbia River and work in support of the Yakama Nation and its efforts to protect sacred lands from the Goldendale Hydro Project. And a bit of background on our speakers today. We have Andrew Hawley, pronouns he, him. He's a senior attorney, and Andrew joined WELC in 2017 as a staff attorney, originally from Valley Forge, Pennsylvania. Andrew earned his BS in biology from Pennsylvania State University and law degree from Lewis and Clark Law School. From 2004 to 2008, Andrew was the Walter Kilman Legal Fellow and then staff attorney at Defenders of Wildlife in Washington, D.C., working to protect North Atlantic right whales, Florida panthers, bald eagles, wolverine, and lynx, among other wildlife. And in 2008, Andrew returned to Oregon to join the Northwest Environmental Defense Center as the organization's first staff attorney, where he focused on Clean Water Act enforcement and protecting the wildlife of the Pacific Northwest. And then we also have Michelle Hoagie, a Deal Fellow, and pronouns she, her. And Michelle joined WELC as a legal fellow in 2023. She returned to her hometown of Seattle for the opportunity following a year working as a judicial clerk in Juneau, Alaska. Michelle earned her JD and a certificate in environmental law from the University of Washington. And at UW, she served as an associate editor-in-chief of the Washington Journal of Social and Environmental Justice, interned with the Klamath-Siskiyou Wildland Center, and co-authored a law review article on the use of eDNA in environmental impact analyses. Previously, Michelle worked in ecology research and elementary education after graduating from Carleton College with a BA in environmental studies. And so with that, I will go ahead and hand it over to Andrew and Michelle whenever you're ready.
Thank you, Michelle. I'm going to go ahead and share our presentation here, and then Andrew is going to kick us off. That visible to all of you. Yeah.
Looks good. Yep.
Oh, I could have. This is our mission. Michelle just ran down for you, and then I'll let Andrew get started. Just tell me when to change slides.
Yeah, great. Thanks, Michelle. And thanks, Michelle. And thank you all, as Michelle said, thank you for taking time out of your day to spend a little time with us. Michelle and I are going to talk about two cases that we have going on in Washington. Well, one just wrapped up, but there's still more work to do. And then another one, we're right in the middle of it. And both those cases involve the Clean Water Act. And so wanted to start off the conversation today just talking a little bit about the Clean Water Act, its structure, so we have some common language. And so if there are, any lingo or acronyms or those sorts of things that we throw at you, hopefully we'll cover those at the beginning so we all are on the same page. And so let's go ahead and jump to the next slide. So the Clean Water Act, the objective of the Clean Water Act is restore and maintain the chemical, physical, and biological integrity of the nation's waters. So in the early 1970s, as Congress and as the nation was kind of becoming more and more aware of environmental problems and the need for holistic solutions to those, one of the main issues was water quality. And so Congress put together the Clean Water Act, passed it in 1972 over the veto of Richard Nixon at the time. So, just interesting to think about that time and place and the bipartisan effort that came together to actually get the Clean Water Act into the books, and then juxtapose that with what's going on in Congress today. But again, what the objective of the act is to make our waters clean again. I can't believe I just used that kind of phraseology, but it's in the lexicon. I can't get away from it. So next slide. To achieve that goal, the Clean Water Act has several achieve that objective. They have several goals that the Clean Water Act laid out. And the first was, and again, so in 1972, looking about as far out as any politician can look, which I think is probably pretty much 12 years or so is kind of the politician's like worldview. That's the furthest away they can imagine anything. By 1983, we were supposed to get our water bodies back into a place where they were what we call swimmable, fishable, and drinkable. Getting to the point where water bodies are good and clean and healthy. And to get there, um, the main goal of the act was to start to move away from using our water bodies as waste removal systems. And so by 1985, we were supposed to get to the point where we're no longer discharging pollutants into surface waters. As part of that, the focus was on toxics and removing toxics and making sure that we weren't directly discharging toxics into our waters. And then again, and we'll talk about the comprehensive scheme of the Clean Water Act in a second, but Congress understood that there were basically a couple different mechanisms how pollutants get into waters. One was from point sources, think factories, pipes, ditches, those sorts of things, but then also from non-point source, from runoff from ag fields or urban areas. And so Congress put in a mechanism to try to address those what are so-called non-point sources of pollution. And so on the next slide, we have Congress kind of put together a fundamental framework, which kind of moving from identifying the types of identifying how we wanted water bodies to work and how they weren't working at the time. And they identified the need to designate water quality standards. And basically, that is thinking about if we want our water bodies to be fishable, swimmable, and drinkable, what water quality do we need to meet those to meet those uses? And so each water body in the United States, and the states have the primacy for this process, they designate the types of uses that the water body could meet. So is it drinking water? Is it fish habitat? Is it a place where there's going to be primary recreation or direct recreation in that water body? So what uses there are for that water body, and then identifying the numeric or narrative criteria for the types of water quality that we want to be able to protect those uses. So if it's drinking water, you don't want to have toxics in it. If it's fish habitat and it's a cold water species, it has to be a certain temperature. So those sorts of numeric or narrative criteria that they could put in place to be able to make sure that those water bodies met those, were able to support those uses. And then also the concept of, well, once we start cleaning up these water bodies, we don't want to go back. And so there's the anti-degradation policy requirement in the water quality standards. It basically says as we start moving water bodies to more cleaner, better, healthier states, we don't want to let them slide back into unhealthy states. And so once we have those designated uses and those criteria established, states just need to go around and look to see which water bodies are or are not meeting those standards and put those water bodies that aren't meeting those standards on the list. And that's called the 303D list of impaired waters. And once we have that list established, then we need cleanup plans. And so you may have heard the term total maximum daily load, TMDLs, and that's basically what the cleanup plan would be for a water body. So if it's not meeting the water quality standards, there's a reason for that. There's something going on in that in that watershed that is preventing that water body from meeting those designated uses, protecting those designated uses, or meeting those criteria. And so we need a cleanup plan. And so basically, it's like, what's the total maximum daily load of pollutants that can go into a water body and still meet those water quality standards? So that's the plan that should be put in place. So that's the overall structure of the Clean Water Act and how we're supposed to understand what water bodies are in terms of their water quality and where we want them to be, and how we can start to then move them into a more clean, protective, healthy state. At the same time, as I mentioned, Congress understood that there were two types of mechanisms driving pollution into water bodies, one from point sources. And so Congress put in a process to directly regulate discharges from point sources, which we'll talk about a little bit more in a second. But the main idea there is if you have a pipe ditch your channel, obviously, and someone's putting pollution into that, you can control that, and should be controlled, one, through the use of technology and the development of technology-based effluent limits, but then also because we are trying to meet the water quality standards, if that technology isn't quite sufficient, another layer of effluent limits called water quality-based effluent limits would need to be put in place to make sure that that facility or whatever it is not causing or contributing to a violation of the water quality standards. And then on the point source side, there's the Section 319 and the plans that are supposed to be developed under that. And again, that's where Congress wanted the states to go out and try to figure out, well, if we have this non-point source, kind of diffuse runoff that's impacting water bodies, what are the mechanisms that the states can put in place to address those types of pollution sources and start working with landowners and the land use level to try to reduce those types of non-point sources. And then sort of in the middle of all of that, there was one area where Congress was very, very cognizant that sometimes the state might not otherwise have the ability to control pollution sources when a federal agency is kind of allowing a project to go forward. So, and as Michelle will talk about in more detail in just a second, one very important section of the Clean Water Act is Section 401 and the certification process that states have where they get to be directly involved in federal licensing or permitting of projects that may have a impact on water quality. And so that's under Section 401 of the statute. But within all that framework, and just want to jump to the next slide quickly, the one thing that I want, if anyone's been on this with me on one of these calls, you've seen this letter before, but I think it's an important reminder about what the Clean Water Act really was trying to do was trying to get us to change how we think about water bodies. For a very long time, and unfortunately kind of still today, many people view water bodies as waste removal systems. Basically, they say the idea is, well, if I dump something in the river, it disappears. It's like magic. And so it just goes away. I'm not just saying that that's just me saying this. The letter that you have on your screen is from the Forest Service in the 1930s, along the Columbia River, there was a Eagle Creek campground, which is very near the Bridge of the Gods, if you know that area, just kind of to the east of Portland. And they had a trash problem at the campground. And so what the Forest Service was doing was they were taking their bags of trash out onto the Bridge of the Gods into the middle of the span and dropping their trash bags into the river. And at the time, there was no Clean Water Act, but the state came out and said, hey, you can't do that. And the Forest Service wrote back, like, what are you talking about? We take it to the deepest part of the river, and it gets dumped out there. Everything should be fine. And by the way, right upstream from here, there's wastewater treatment facilities that are dumping sewage into the river. So how bad can it be? But what the Clean Water Act was trying to tell everyone and remind everyone was, and actually, as the next slide shows, we're all downstream. And what we have to do is stop thinking about, we have to stop thinking about streams and rivers as a way to get rid of waste. And that was the whole goal of eliminating point source discharges by 1985. That's really the fundamental goal of the act is to, yes, make water bodies more healthy, but we have to stop using them as a way to just get rid of waste because someone's downstream from that. And that was the whole point of the Clean Water Act. And so I think with that overview, Michelle, unless you have anything else to add to that, why don't you jump into the Goldendale conversation?
Here we go. And I'll quickly state that our excellent communications associate Sue's created this design for our t-shirts, which Michelle can tell us later if they're publicly available yet, but if not yet, they will be soon. She's a great artist. And there we go. So I'm going to continue talking legal stuff on how Section 401 of the Clean Water Act works. I'm going to speed through this a little bit just to ensure that we get to hear both about our Goldendale case and the CAFO work Andrew's been doing. But anything that I don't cover, you are welcome to ask questions about at the end, and we'll try to save as much time as we can for questions. So, as Andrew described, Section 401 is the part of the Clean Water Act that gives states the ability to weigh in on federal actions that involve discharging water, potentially polluted water, to waters in the relevant state or an interstate area. But and this state here has the authority to, well, and to research what's potentially going to happen as a result of this project and evaluate whether any conditions should be placed on the project to ensure that water quality requirements are complied with. And we'll get into the weeds of historically also to ensure other state laws are complied with, and follow up on that in a second. So what 401 says directly is that the certification issued by a state should set forth effluent limitations as well as monitoring requirements. Monitoring is really important to ensuring that, once limits are set, they're actually being complied with once the project starts operating. And that the state can set any such limits necessary to assure that the applicant for the federal permit will meet other state effluent limitations as well as other appropriate requirements of state law. And that includes the total maximum daily loads and a few other components that Andrew gave an overview of earlier. And then what's written in the certification automatically becomes part of the conditions that the permittee has to comply with when the federal agency, in our case, FERC, or the Federal Energy Regulatory Commission, issues their license for the project. So we've been working for a good couple of years now on challenging this proposed hydroelectric project along the Columbia River in the Golden Dale area, so central Washington, south of Yakima. And if you were with us about a year ago, Andrew and I gave a talk where we were discussing, at that point in time, we were in front of the State Pollution Control Hearings Board with co-plaintiffs, the Confederated Tribes and Bands of the Yakima Nation, we were representing Columbia Riverkeeper against the State Department of Ecology, who had written has written a 401 certification that we think is insufficiently protective of water quality, and also, unfortunately, could allow this project to go forward, causing a variety of other negative impacts that we'll talk about more in a second. But so we argued this case in front of the PCHB, the State Hearings Board, which is the first place to hear an appeal of a certification written by the state. That hearing was held last August, and the board found against us, so we've since appealed to state court, which is a forum we're working in now. So this is our new case number. We're at Thurston County Superior Court, and we and the Yakima Nation appealed this case separately because we have independent sets of interests, Yakima Nation and the Columbia Riverkeeper, in what's going on here. Or what is proposed to happen. But just this morning, we got an order from the court consolidating those two cases. So we'll be continuing to work with the attorneys for the nation in arguing to the state court that there's a few good reasons this project shouldn't proceed. So one of the big legal wrinkles in this case, which I'll go through just really quickly, is that the certification Ecology wrote here was written and released during a really brief period of time, less than a year, when the first Trump administration's regulations governing the 401 process were in effect. So there was a set of regulations telling states how they should conduct their 401 certifications prior to 2020 for many years. And then these rules were in effect for less than a year. And then the Biden administration rewrote them again. And the ones we're dealing with really severely limited the scope of review for the state when considering what all the impacts of this project could be. And I'm going to talk more in a second about what exactly the project looks like. But just to frame up that conversation, what we're dealing with right now in our fight against Ecology and its kind of choices to greenlight this project, despite some potentially dangerous impacts is that ecology, the state of Washington, including the department head in 2020, came out really strongly against these regulations and how they limited the state's authority to protect water quality in our own backyard. And in this case, by requiring the state to only look at direct discharge impacts rather than impacts of the activity as a whole. Despite all that, ecology did what they did in allowing the Goldendale project to move forward, and are now arguing that it was reasonable and necessary for them to not look beyond the direct impacts of discharges to waters in the state. And that has focused our case about the Goldendale project pretty narrowly into the potential discharges to the Columbia River. And I'll talk more about that in a moment, but to give you all a sense of why it's so important that we continue our work on this case, even though the board and the state of the law has kind of limited what we're allowed to argue about in terms of whether water will be discharged into the Columbia through groundwater. Besides impacts to the river and other water bodies in the area, the really big problem with this proposal is that it sits right on top of sites in the yellow outlined area here that are of extreme importance and sacred significance to the Yakima Nation as well as other Native peoples in the area. I'll show a map in a second of who this affects, but it is on the ceded territories of the Yakima, their Treaty of 1855. So there's a great video on Yakima Nation's fisheries website if you want to learn a little bit more about why energy development in this part of Washington has had some negative impacts over many decades, particularly on the Native people there and the sovereign interests of the Yakima Nation. And I think probably need to speed things up a little bit, so I'll just leave you to please do more research on that if you're interested. This is the site near the John Day Dam where the project is proposed. As you can see, the wind turbines here, the part of the point of having a pumped storage hydroelectric system, which is exactly what's proposed here along the river, is to store energy, especially with the build out of renewable energy, wind and solar, both of which, unlike fossil fuels, have an intermittency problem, is the way people who manage electrical grids talk about it. The solar energy, you can only get it during the daytime and when it's sunny, which fortunately it is sunny very often in central Washington. But and same with wind, it depends on how much wind is blowing. So this is kind of a cross between a battery and a hydro project. The whole idea is that when there's extra energy available on the grid, water gets pumped uphill. And then when the grid needs more electricity, water rolls downhill through a turbine system, generating electricity. And happy to expand on that a little bit more, but the main concern we have as stated is that the place this project is proposed is just a dangerous place to put this kind of project, even if it could serve some needs that we have as far as our transition to a more renewable energy system. There are better alternatives to what the developer is trying to cause to happen here. So it includes these two large reservoirs, big, like very, very big concreted areas that will store water. And then as water evaporates over time from those reservoirs, it's likely to become highly concentrated in terms of pollutants, especially pollutants that are in the soil from a nearby former aluminum smelter site. There are also a lot of recreation areas along this stretch of the river. But as mentioned, the Yakima, Umatilla, Warm Springs, and Nez Perce tribes have historical and present interests in the integrity of this landscape. It's one of the highest points on the landscape on this stretch of the Columbia, and it's been occupied as well as used for food gathering and ceremonial purposes for hundreds and hundreds of years. I won't read all of this because it's really not all my story to tell, but these are quotes from the Yakama Nation as well as the Umatilla about the significance of the two major sacred sites right where the project is proposed, as well as there's additional cultural properties in the vicinity. But it's a seed bank for a lot of traditional foods on top of having other spiritual significance. Um, and unfortunately, all of the impacts to traditional cultural resources and particular sites were excluded from ecology's certification, 401 certification, because of the Trump 401 regulations directing that certification should only consider direct impacts from discharge of waters to navigable waterways. So even though ecology also wrote in its environmental impact statement that the impacts to tribal resources were going to be impossible to mitigate and severe, it did not say anything in the certification about those impacts. What we are now talking about is the potential impacts to the Columbia River itself and the fact that ecology did not write about those in the certification either. So the environmental impact statement the agency prepared discussed leakage from the piping in the reservoirs, particularly the pipe connecting the three reservoirs to groundwater, which would ultimately reach the Columbia River. And as I mentioned, there's potential for that water to be highly contaminated. And however, the certification doesn't include anything about discharges to the Columbia River, doesn't include monitoring for those discharges, and doesn't consider the potential impacts to water quality, including in terms of toxins, temperature, and the various designated use of ammonia in this area. The really interesting adventure Angie and I went on along with Yakama Nation's attorneys at our hearing before the PCHB was that ecology took the position in its litigation that the project would not actually leak, even though the original proposed project proposed this enormous amount of leakage equivalent to about 90,000 gallons a day on average into groundwater. The new plans that the developer has shown with ecology suggest there will be no leakage whatsoever. And if there is, they've also said, and the board decided there is any leakage, there would be adaptive management. They could do something about it later. But because there's no monitoring in the certification, there's really no way right now, if this project were to go forward, to find out if water was leaking, how much, and what kind of impact that was having on the Columbia River. So our appeal is focusing on the differences between the project that was proposed and discussed in the environmental impact statement and what the certification actually addresses and deals. And we can answer more questions about what that's going to look like later, but we're in the middle of the litigation right now, moving forward in state court. And I think I'll pass things on to Andrew now to talk about a recent big win also for Washington's.
Great. Thank you. So we're going to shift gears now from Section 401 of the Clean Water Act back to Section 402 of the Clean Water Act. And again, so as I mentioned earlier, one of the main goals of the Clean Water Act was to eliminate exactly what you're seeing now, the discharge of pollutants to navigable waters, to waters of the U.S. from point sources. And so, point sources is defined as pipe, distant channels, but it's also defined as concentrated animal feeding operations. And we'll talk about those in detail. But again, as we go through this, I just wanted to again highlight some of the specific legal requirements for these types of national pollutant discharge elimination. It says right there in the title, system permits. And what these permits need to do is if they're going to allow the discharge of pollutants to our waters first ecology and ecology in Washington has the permitting authority has to establish technology-based effluent limits. So for each industry sector, they have to go around and look at, well, what does this industry, what do they discharge? And what technologies are out there to reduce or hopefully eliminate those discharges? And whatever the technology is, that has to be the first kind of line of defense. And in Washington, we actually have an additional layer of requirements there. Since the 40s, anyone who wants to discharge pollutants into Washington water has to be using all known, available, and reasonable treatment to eliminate or at least reduce those discharges. So that's the ACART standard under Washington law. And so that is basically a Washington equivalent or addition to the technology-based effluent limits. And then, as I said, again, if those technology-based limits or the ACART standard isn't sufficient to ensure compliance with water quality standards, then the permit writer has to put in additional effluent limits that will ensure compliance with the water quality standards of the receiving waters. And so, again, to ensure that those waters are maintained at a swimmable, fishable, drinkable level of quality. And then finally, the other important component is that the MPDS permitting system is built off of a requirement that the permittees themselves monitor and report how they're doing in compliance with their permit. And some folks have questions like, well, that seems like the fox watching the hen house, which it is, but it puts the onus on the facility itself to put the time and effort and money and resources into that monitoring. And nice thing for us and for the regulators is that then they have to make that information publicly available and disclose it. And there are rules around whether or not, how often they do it and they can't lie when they do it. And so it creates this kind of self-enforcing mechanism that one lets us look to see if the permittees are complying with the permits, but then also to see if the permits are working. And so that monitoring element is essential to the effective permitting system. And so, next slide. As I said, one of the types of facilities that has to get these MPDS permits are CAFOs, and CAFOs are concentrated animal feeding operations, and it basically it says that's what they are. They are facilities that, and we can actually go to the next slide. Facilities that take a lot of animals and put them into a confined area and then feed them and to do something with them. So it's either going to be cows that are either going to be turned into meat, or dairy cows, or pigs, or chickens, or some other livestock that the facility, instead of having them pasture raised and all those sorts of good things, looks like this, where it's a very um, concentrated activity. And as you can imagine, there are several different types of problems that can come from these types of facilities. And so first is the production area, kind of the area where the animals are housed and all of the industrial mechanism that goes into raising those animals. So this is where you have all the animals, they're creating their waste. We'll talk about where that goes on the facility in a second, but you have your, industrial facility type problems with your machinery, and with animals, you have your pesticides and your antibiotics and all those sorts of things, and all the problems, the waste problems that can come from that. And then on the next slide, when you have that many animals, they have waste. And so the first level of waste is the dry waste. And so what these facilities do is they have a composting area. And they take all the dry waste and put it in there. But in Washington and anywhere else where it rains, those large piles, and in Yakima Nation, there was one composting area that was actually over 90 acres of just compost. They create their own problems. But then you also have, and on the next slide, you have the liquid waste problem. And so you have basically these facilities have these large lagoons. Some of them are lined like the metal structure on the left, but then some of them are just dirt holes where they just put the liquid waste into those. And those structures have been shown to leak time and again. And so there's a significant problem with impacts to groundwater from those facilities. And also if they ever fail, the potential for discharges to surface area or to surface waters. But then that liquid manure eventually has to go somewhere. And so the next slide is that liquid manure is then spread out onto ag fields. And that's a problem both for groundwater, because when the manure is over applied, the nutrients, the nitrogen and phosphorus will leach into groundwater. But then many times, will either be over applied in sheet flow to surface water, or there are things called tile drains, which are drains, put out throughout the fields to keep the moisture level at where the farmer wants it, but those drains are a direct discharge to surface water. And so as that manure gets spread, that those pollutants get into surface waters. And so WELC has been working on this issue in Washington for 2 decades now. We've brought 3 different lawsuits over what ecology has done is they've issued a general permit to cover all of the facilities, all of the CAFOs in Washington, and mainly in Washington we have dairy CAFOs. That's the largest industrial sector in CAFOs in Washington. There are somewhere between 300 and 400 CAFOs in Washington that should have this permit. Unfortunately, for things we're not going to go into today, only a dozen or so of those facilities actually have this permit. That's another problem we're going to try to figure out how to work on. But we've brought several different cases challenging that permit. Several years ago, in 2001, we won one of those cases, and we finally got the court in Washington to hold that what Ecology was doing was unlawful and that their permits didn't actually comply with the law. And here are the 4 or 5 specific things that the Court of Appeals in that case said that Ecology wasn't doing well. One, they weren't complying with ACART for the existing manure lagoons and for the composting areas. To the rules that they had for discharging pollutants onto to manure onto the ag fields weren't sufficient to ensure compliance with water quality standards. They didn't have sufficient monitoring for both groundwater and surface water. The permits failed to protect surface water or groundwater from the potential impacts from the lagoons, the composting areas, and the land application. Another important part was under the CAFO general permit scheme, there's the general permit that kind of lays out the basic principles that each facility has to apply, but then there's a specific individual site-specific document that they have to write called a nutrient management plan, which is supposed to lay out the details of how that facility is going to comply with those permit requirements. And that plan by law is supposed to be put out for public comment and review, because that's really where the rubber is going to hit the road. And Ecology wasn't putting that out for public comment or review. And then finally, under our state Environmental Policy Act, Ecology hadn't taken into consideration the impacts of climate change on these facilities and how that might change how they impact water quality. So we got that win at the Court of Appeals. Ecology went back and wrote a new permit. We commented on it. We did our best to try to get them to make all the necessary changes to comply with the Court of Appeals decision and also just generally come into compliance with the law. But unfortunately, they didn't. And so on the next slide, we ended up having to go back to court to challenge the permit again. So that permit came out in 2022. We challenged it immediately, and we went back in front of the Pollution Control Hearings Board, which again is the administrative body that hears these types of challenges. And we had several issues that we wanted to raise there. Very unfortunate typo in the first bullet there, but the clients that we had in this case were Friends of Toppenish Creek, Puget Sound Keeper Alliance, Center for Food Safety, Sierra Club, Waterkeeper Alliance, and Food and Water Watch, which again is unfortunately not on that slide. So that was the group of clients that we were representing at the PCHB, and again we were raising some of the same issues, unfortunately, that we had raised in the prior 2 cases. And so we went through the PCHB process, and submitted our opening brief on all of these issues, explaining again to the court why what ecology was doing wasn't consistent with the Clean Water Act and the implementing regulations under state and federal law. And shockingly, I've never actually had this happen before, but Ecology came back in their response brief and said, you know what? You're right. You're right on four, I think three or four, depending on how you count, of those issues. And so, gonna run through quickly what we won on because when one side concedes something like that, the court's more than happy to take that. And what happened was the court incorporated those into its final decision and remanded to ecology to fix these issues. So on the next slide, the first the first um, the first place that the first issue that we won on was um, as I said, each facility that gets this permit has to come up with a nutrient management plan that kind of talks about how they're going to deal with all of the manure that these facilities are creating. And the main point there is to figure out, well, what's going to happen with you when you take that liquid manure and you spread it out onto the fields? Where's it going to go? And so there has to be a so-called field-specific nutrient transport assessment. And that just was fundamentally missing from the requirements in the permit that the permittees were going to have to go out and do this specific assessment. And this is really important in Washington and anywhere there are CAFOs for one particular reason in Washington is until now, basically ecology said, well, we're going to look at just the nutrients based on nitrogen. Even though there are two nutrients in play, nitrogen and phosphorus. And ecology had the concept, oh, if we just regulate for nitrogen, that's going to be enough. We're going to understand what's happening on these fields, and that'll be good enough. The problem is, and ecology admitted this as they were writing these permits, that there's actually way too much phosphorus in many of the fields, particularly in eastern Oregon or eastern Washington. And I'm going to paraphrase, but almost quote, if phosphorus were the limiting were used to regulate these facilities, no facility would be able to add any more manure onto these fields because there's just way too much phosphorus and the plants can't uptake it. And so it's going to go somewhere. Either it's going to sheet flow off into creeks or go through tile drains into creeks, or it's going to leach into groundwater. And so if they limited these fields based on phosphorus, they're going to have to stop applying this manure, which is going to be a huge problem for the CAFOs because they have no place else to put this manure. And so the absence of the field-specific nutrient transport assessment allowed them to basically turn a blind eye to phosphorus. So now when they're going back, rewriting this permit and requiring that as a specific part of the analysis, they're going to have to take phosphorus into account, which I think is going to be it's going to be really interesting to see what these facilities are going to need to do to address that problem. The second issue on the next slide is one of the changes that ecology did make in the 2022 version of the permit was they did require some facilities to actually start to monitor impacts to groundwater. And they just said, well, the really big facilities in the areas where we know we have nitrogen problems in groundwater already, we're going to require them to monitor their discharges to groundwater. That was a nice first step, but the problem is it wasn't lawful. The Clean Water Act requires monitoring for all the potential pollutants that are going to be discharged from a facility. So even small facilities in areas where we knew we didn't already have nitrogen problems were required should have been required from the get-go to monitor their groundwater discharges. Ecology admitted in their briefing that they had made a mistake on that they were wrong, and that they were going to have to require all facilities to monitor for groundwater and monitor their impacts to groundwater. And again, this is a huge change. This is something that the industry has fought for a long time. They don't want to have to do this. One, because I think they know that they have a serious problem. And two, it's hard. It's expensive. It's difficult to monitor discharges to groundwater, but that's a problem they're just going to have to figure out. It's cost of doing business. If they're going to have unlined lagoons with manure in it that we know leak when they're unlined, well, then they have to monitor and they're going to have to address the fact that the impacts that they're having on groundwater. If they want to get to a place where they know they're not discharging to groundwater, okay, that's fine. We can see the industry moving in that direction, and that's great. But until then, monitoring their potential discharges to groundwater is essential. And so that's a huge step in the right direction. And then finally, on the next slide, one of the again, and this was an instance where the permit writer just admitted that she just made a mistake and she just did not do a good job, which was you know a nice bit of candor on her part, but also frustrating that it was a multi or many year process of developing the permit, and these mistakes are still made. There was no requirement for the facilities to use the best treatment technology or control technology for composting areas. Again, as I said, for example, in Yakima County, there was one facility that their composting area was 90 acres. And they weren't covering the compost. They weren't using impermeable surfaces to under the compost. And so that those composting areas were leaching nutrients to groundwater. And it was a known problem and something that these facilities are just going to have to figure out how to address under the ACART standard. And so that was a place where, again, ecology admitted that they had made a mistake, and that they're going to need to go back and fix the permit. And then finally, um, again, despite the fact that the Court of Appeals had told them that uh, obviously nutrient management plans have to go out for public comment, the way the permit was written, not all nutrient management plans for all the covered facilities were going to go out for public comment, and allow that process to go forward before a facility got a permit. And so that's again something ecology admitted that they had made a mistake on, and that they were going to have to go back and change the permit language. And again, this is really important because this is, the site-specific management plan where these facilities are going to have to explain how they're going to meet all the requirements of the permit and the law. And having that available for the public to be able to scrutinize, review, comment, and suggest changes is vitally important in terms of the public participation, and exceedingly important, particularly for the folks who live near these facilities and want to see them change. Um, Unfortunately, the case was not a complete win, and there's still some work for us to do. We had three other claims that I think are important. The first one was, right now, we just feel like the ecology allows too much application of manure to fields. And that was an area where ecology has an adaptive management process where they say that, well, we'll keep monitoring the fields, and when they get to certain levels, then we'll tell folks to kind of turn off the taps. This is a big gun of, basically just shooting manure onto this field. Um, we think the science says that the standards that ecology uses for that adaptive management processes are just much too high. They allow way too much nitrogen to be applied to those fields, and it doesn't really address phosphorus. And so we think that that's a place where ecology needs to continue to improve the permit. And so as the permit goes back through the revision process, which is at ecology again, we'll be starting up this spring, into this summer. This is a place where we're going to continue to push. The second place where we think ecology has still failed to address the a potential significant issue is they don't require the facilities to look at the toxicity of the pollutants that they're spreading on the fields or allowing to be discharged from the facilities. And so there's a requirement under the law that anyone who's discharging to a water body where there might be toxic elements to it, they have to go through what's known as a whole effluent toxicity test, a wet test. And here ecology just simply has never required CAFOs to go through that process. And so that's something that we think should clearly be in the permit. And then finally, right now, ecology it doesn't have a sufficient surface water monitoring component within the permit. Basically, what we want to see is upstream and downstream monitoring of surface waters around CAFOs and around the field applications. Because, as I said, sometimes the manure will sheet flow off onto surface water. Sometimes it will be captured by tile drains and discharged, and sometimes the pollutants will be infiltrated into groundwater, and then that groundwater is hydrologically connected to surface water. And so without a monitoring mechanism to address all those various ways that pollutants might get into surface waters, we're kind of flying blind, and we don't actually know if the facilities are, one, complying with their management practices, and then two, if the permit's actually protective. And so that's an area where we're going to continue to push ecology to improve its permit and require a comprehensive surface water monitoring program so that we actually can understand the full impacts from these facilities. And so as I said, we wanted the PCHB. They issued a decision earlier this year, kind of adopting the places where ecology said that it needed to go back and rewrite the permit, ruling against us on a few things. But ecology is going to go back through a permit writing process again, as I said, this spring or summer. And we will be continuing to work with our partners in Washington on that process to try to continue to push ecology to get this permit into better shape and in compliance with the law. And with that, I think that is all we have. So any questions from the group?
I'll also jump in here just while if anyone's thinking of any questions, that our winner of our stainless steel cup t-shirt is Taylor Priest. So Taylor, I will reach out to you and make sure you get that cup sent to you. And also just big shout out, thank you, Andrew and Michelle, for all your work and everything that you do for these important projects. So go ahead with questions and feel free, folks, to just raise your hand to ask the question if that's easier, or typing it in the chat box.
Try and answer really quickly the one question I saw in the chat so far. It's not quite what we're working on, but someone had asked about bird flu detections in the Washington dairy cattle, and I did some follow-up research on that. To my knowledge, bird flu has not been detected in Washington in cattle yet, but it has been detected in cattle in other states. It sounds like that's been spreading for over a year, and I think including Oregon. One unfortunate piece of news that just came out this week is that the Food and Drug Administration has suspended a program to test raw milk for bird flu, which began in December of last year. Suspended it as a result of staffing cuts at the agency. So just one more reason to stay involved in your community and your government. But I'll see if we have any other questions.
Yeah, I think I can take Bill's question on how facilities are going to can manage the manure. And I think it's kind of two parts. One, as I said, these are CAFOs are one type of way to have a dairy farm. You have a lot of cows in one area, and then you have to deal with their manure kind of as it comes. And so that kind of forces you to put that manure into storage tanks and compost for the dry. And if you're going to have a CAFO, that you're just going to have too much manure to deal with. And so if you're going to have that facility, you have to have basically you have to have systems in place to keep those pollutants where they are. And so you can't have unlined uh, manure ponds, and you can't have composting areas where the compost is uncovered or it's on permeable surfaces. So that's the transition that these facilities have to make, is to lined lagoons, and then to composting areas where precipitation isn't a problem. The other the other avenue is to move away from the CAFO model, and move back to smaller farms where you don't have that excess of manure in that causes the problems when it's just in these quantities. And so that's the solution, is either they have to, physically manage it in a different way than they have in the past, or they have to change their business model and move to more, what we think is more sustainable, healthier farming practices. Yeah, so looking at the question around grazing on public lands. Um, Again, so that is a slightly different issue than the CAFOs, and kind of the other problem with kind of ag industry in the United States in terms of CAFOs. They take them all and put them into one place and then deal with those problems. When we have grazing on federal lands, where livestock is not fenced back from streams and other water bodies, there are, potential impacts to water quality there. There are some rules around those sorts of things. Some folks have tried to bring some pretty creative cases to try to make the federal government be more proactive about protecting water quality. They've been met with some success and some not. It's just another fight that we're not directly involved in. Um, from a water quality perspective at this point, but it certainly is something that we've been tracking and just have not come into a situation where we've been asked to bring that type of case yet. On the question of can CAFOs operate better? Well, yes, actually. As I mentioned, there is technology. I mean, I would just say I think I don't want to speak for my clients, but I think just generally CAFOs are a bad business model. Just how they operate and just the amount of waste that they generate. Not even getting into the animal rights issues around having that many cows in one place. Um, setting all of that aside, if CAFOs are going to exist, there is technology to do it better. And frankly, one of WELC's attorneys, Charlie Tebbit, who actually began a lot of our CAFO work 20 plus years ago, has sued many CAFOs in Washington and has gotten them to individually put in technology that prevents a lot of the problems that they cause. Not all of the problems, because they still have to put that manure somewhere and they're still over applying it to fields. But in terms of lined lagoons and better management within the facility and the composting areas, this is not it's not rocket science in terms of double synthetic liners with leak detection for the lagoons, and covering composting areas and impervious surfaces, and managing that runoff in a way that makes sense. It is possible. But it's going to be always an ongoing challenge with CAFOs, just because of their size and complexity and the amount of manure that they're creating.
Thank you, Andrew. And I think looking at the time, just to be conscious of everyone's day, we'll wrap up there. But of course, if any questions come up, definitely feel welcome to shoot any of us an email. But just want to say a big thank you for, again, showing up. Thank you, Michelle and Andrew, for all your work. And WELC and Michelle and Andrew wouldn't be able to do this work without our supporters. So huge gratitude just all around, and just reiterating again how important it is, more than ever, to be showing up in your communities in whatever capacity that you have. So a lot of gratitude all around to everyone. And I hope everyone enjoys the rest of your day. And Andrew and Michelle, I don't know if you had any other final thoughts, but otherwise we'll wrap it up.
Thank you all for being here.
Yeah, thanks for coming. Thanks for the great questions.
All right. Have a good one, everyone. Bye.